So here we want to talk about the non-freehold estates and tenancies, which is much different than freehold. Remember, freehold estates means ownership. Freehold means ownership, means you own the property. Non-freehold means you lease the property, but that's still a form of ownership, and we're going to talk about this as we go through. In fact, another term you could hear instead of non-freehold, sometimes you hear it called leasehold. Obviously, it's the same thing. So that's what we want to kind of talk about here. Now, how do you create a non-freehold estate? Y'all, they could ask you this on the exam. Obviously, by signing a lease agreement. So if you're a tenant, you sign a lease agreement, you're going to rent this property for X amount of time. You've now created a non-freehold or leasehold estate. Now, with that, do you now own, I say you, does the tenant now own any interest in that property as a tenant? And the answer is yes, they do. Well, what interest is that included? You know, if you watch the video that I did on freehold estates, we kind of touched on this a little bit there, but anytime you own interest in land, if you own interest in land, whether it be freehold or non-freehold, that legally comes with the bundle of legal rights. And if you're not sure what that bundle of rights are, you need to make sure you know it. That will be on the exam, okay, on your real estate exam. So make sure you know it. There are 5 things, and you see them listed here. But the bundle of rights includes the right to use, the right to control the property, the right of possession, the right of disposition, and the right to quiet enjoyment. Now, we're going to break these down a little bit more towards the end of this video. But for now, I just want you to know, if you own interest in land, whether it be freehold or non-freehold, it always includes the bundle of rights. Okay, so keep that in mind. So that's what a non-freehold estate is. Pretty simple there. But now we need to kind of go over the different types of tenancies that you would see, obviously, with a non-freehold estate. This will be on the exam, so you need to be familiar with these tenancies. And by the way, remember, tenancy has 2 different definitions depending on which or what type of estate you're referring to. Remember, if you were dealing with a freehold estate, freehold means how the land is held. Okay, in other words, is there just one owner of the property, or are there multiple owners of the property? Y'all, that's what tenancy means with freehold. But right here, we're talking about non-freehold. And now tenancy means something different. Now it means duration or length of time. That's what we're dealing with these types of tenancies. Now, the first type of tenancy is what we call an estate for years. Y'all, all that means is there's an expiration date agreed upon in the lease. That's all it means. It's no more difficult than that. There's an expiration date in the lease. That makes it an estate for years. Now, let me just tell you, and here's where I think a lot of people might have problems on the exam, and something you want to be careful of here. It seems like when people hear the estate for years, in our mind, we assume that's a 1-year lease. Now look, it could be a 1-year lease, but it does not have to be. You know, maybe I've got a property that I rent out, and I'm only going to rent it for 6 months. And I put in the lease, it will expire on this day, which would be 6 months from the start of it. Well, because I put an expiration date, that's what makes it an estate for years. So y'all, don't confuse estate for years with a 1-year lease. That's not what that means. Y'all, I might rent the property out for 1 week. As long as I named and expressed an expiration date, it's now an estate for years. That's what that means, expiration date. All right. So if I have an estate for years, or the tenant rather has an estate for years, does the tenant have to give notice to terminate the lease? And the answer is no. Why does the tenant have to notify the landlord that they're going to terminate the lease when the lease already says it will terminate on whatever date? So there's no notice required for termination. And I know I get questions on this a lot, like, well, I know my landlord requires me to notify them if we're going to terminate or whatever. Look, what the landlord is probably doing, they just want to know, do you have plans maybe to extend the lease and stay longer, or are you in fact going to be moving out on that day? But from a legal standpoint, there's no notice required to terminate. It's going to terminate. But as the landlord, if we're going to terminate the lease and you're going to move out, then I want to go ahead and start finding or looking for another tenant. That's all the landlord is doing here. When for example, they might put in the lease, tenant must give 30 days notice if they want to terminate. Look, there's no legal requirement to give that notice, whether it's in the lease or not. What the landlord is asking for is, if you're not going to renew the lease, please give us 30 days notice so that we can start marketing and advertising, looking for another tenant. That's all they're doing there, okay? So there's no notice required to terminate if it's in the state for years. Now, the next tenancy is a periodic tenancy, or sometimes you might hear it referred to as a period to period. And really, all this does is establish how often you pay your rent. For example, if the lease states that your rent is due every month, maybe the first of every month, then your periodic tenancy is a month to month, meaning your rent is due every month. If you paid your rent every week, then your tenancy or periodic tenancy would be week to week. That's all that's establishing. So your periodic tenancy establishes how often you pay your rent. That's really all that's doing. And then the next tenancy is the tenancy at will. A tenancy at will means you have a lease, but there's no expiration date. So in essence, as long as the tenant's willing to stay and pay the rent, and the landlord's willing for the tenant to stay and will accept the rent, then we just continue on. We just drive on. It's just there is no expiration date. Well, when you have no expiration date as a tenancy at will, then if the tenant or landlord, if either party wants to terminate the lease, now will that party have to give notice to the other party? And the answer is yes. Now there's a legal requirement to give notice to terminate because there was no agreed upon termination date in the lease, right? That's a tenancy at will. Now, a question you might want to be familiar with is, well, if we do have to give notice under this tenancy at will, how much notice must the tenant give the landlord, or vice versa, if they wish to terminate the lease? Well, the answer goes back to what the periodic tenancy is that we just talked about. If the periodic tenancy is month to month, which means you pay your rent every month, first of every month, then that means you must give 30 days notice to terminate. If your periodic tenancy was week to week, obviously you paid your rent every week, then you must give 1 week's notice to terminate. So really that periodic tenancy that we talked about on the previous slide establishes two things: how often you pay your rent, and two, how much notice must be given if one of the parties wants to terminate the lease under a tenancy at will. Okay, now you'll see this last bullet here, but y'all, let's say the tenant dies. And again, we're talking about a tenancy at will. Now you need to pay attention to what I'm about to tell you right here, because I don't want this to become confusing. But if it's a periodic tenancy and the tenant dies during the term of the lease, does that terminate the lease? And the answer is absolutely. Y'all, you'll find death has a way of terminating a lot of things, but this lease, it will terminate. So death of a tenant automatically terminates a tenancy at will. But let's go back and look at something here. Y'all, what if it was the estate for years? Which means you had an expiration date named in the lease. Now that's going to be a little bit different. Y'all, let's say for example, I've got a lease that states the lease will expire December 30th, okay? And maybe I'm in June right now. So obviously I've still got 6 months before the lease expires according to the lease. Well, but let's say the tenant dies and there's still 6 months on the lease. Well, if the tenant dies under an estate for years, does that terminate the lease? And the answer is no, or at least not automatically. That does not terminate the lease. So legally speaking, tenant, even though you're dead, you're still responsible, liable for the rent that you agreed to pay through the end of December. Because see, here's what you're doing, if this will help make more sense. But I don't think a lot of landlords and certainly tenants understand this, what I'm about to tell you. Let's say the tenant and landlord sign a 1-year lease that happens to be in estate for years, meaning we named an expiration date that will expire in 1 year. Basically, what you're agreeing to is, tenant, you agree to pay $12,000 to live and to lease this property for 1 year. You agree to $12,000. Now we're also going to agree, instead of you paying that all up front, we're going to agree to a periodic tenancy, for example, a month to month, where you can make monthly installments. So basically your rent's going to be $1,000 a month. And as long as you paid that $1,000 a month, that will pay off what you're obligated to pay, the $12,000 you owe at the end of the year. Well, if you die 6 months into it, you still owe 6 months worth of rent because you agreed to pay $12,000. That's what you agreed to pay, assuming that's what the annual amount of rent would have been. Y'all, and I know this is kind of a weird analogy here, but y'all, what if you bought a house and you're making payments to the bank? Y'all, every month you have to make a house payment. Well, if you die before the house is paid off, does the bank just say, well, you know what? The buyer died, so the money he still owes us, we're just out of that money. No, the bank still wants their money. How are they going to get it? If you're dead, well, that's what probate's for, right? So the debt has to be paid off. Well, it's very similar with what we're talking about here with a non-freehold estate, or at least under an estate for years. So legally speaking, could the landlord file a lien or a suit, if you will, with the probate saying, look, this tenant agreed to pay me $12,000. They've only paid me $6,000. They still owe me for the next 6 months, another $6,000. And they can do that. Now I'm going to tell you that's not very common and probably not very practical, but I'm just saying legally they have the right to do it. And I'm sure some have done it. Well, if they do that, and by the way, if they present that lease to the probate court, that's going to have to be paid out of the estate. It will have to be paid. Now, if they do that, can the landlord now go and rent it to somebody else? No, can't do that. Basically, the estate now owns that remaining interest through the end of the year. And maybe the estate can put somebody in there. Maybe there's a family member that needs a place to live and they had to pay for this period of time. So we're going to let this family member stay there. And landlord, you're stuck with that. So you can't sue, I say sue. You can't file a claim for that money and then try to terminate that lease. That you can't do that. Okay. Now, having said that, what most landlords would do is just go ahead and terminate the lease. The landlord can do that. Y'all, if the tenant dies, then they could go ahead and terminate the lease and then just look for another tenant. Y'all, you can do that. But look, the only thing I'm trying to make clear is this. Under a tenancy at will, if a tenant dies, that automatically terminates the lease because there is no expiration date. But if it happened to be an estate for years, meaning there is an expiration date, then the death of the tenant will not automatically terminate the lease. It's up to the landlord on whether they're willing to go ahead and terminate the lease and get another tenant, or whether they want to go to probate. Y'all, I hope that wasn't too confusing, but y'all want to make sure you understand it. All right. Y'all, this next tenancy is, they just call it tenancy by sufferance. And y'all, I'm going to tell you that's a very practical title here. Y'all, tenancy by sufferance just means you have a lease that has expired, but the tenants decided, but I'm not moving. In fact, not only am I not leaving, I'm not going to pay any more rent either. So obviously that creates suffering on part of the landlord. Y'all, they call that tenancy by sufferance. Obviously the landlord would have to take legal action at that point to have the tenant removed. But now here's this bundle of legal rights that we want to just touch on for a minute. Y'all remember we said if you own interest in land, whether it be freehold or non-freehold, either one, it always comes with the bundle of legal rights. And here they are. Y'all, most of these I think are self-explanatory, but a couple of them I think we need to talk about just a little bit. But obviously if I'm a tenant, do I now have the right to use that property? Absolutely. Do I now have possession of the property? Yeah, absolutely. Because obviously you're going to be living there, you're going to be staying there, you're now in possession. You now have control of the property. It's yours during that period of time that was agreed upon. But disposition. Now what does disposition mean? Y'all, disposition means you have the right to dispose of your interest. Y'all, to get rid of it, do away with it. That's what disposition means. But there are some differences between the freehold interest and the non-freehold interest. For example, if it's freehold, meaning you own the property, disposition would mean you have the right to sell it or to give it away. Y'all, that's how you would dispose of, get rid of your interest. Y'all, you'd sell it or give it to somebody else. Then you've disposed of your interest. Well, do you have the right to disposition if you own that property? Yeah, absolutely. Y'all, it says it right here. Well, but what if you're a tenant? Again, we're talking now non-freehold estate. Does the tenant also have the right of disposition? And your answer is yes, they do. However, it means something different for the tenant. Tenant, you can't go sell the property because you don't have an ownership. You don't actually own the property, right? You don't have a freehold interest. But what it means to the tenant is the tenant has the right to sublet or assign. So they could sublet the lease to somebody else or assign it to somebody else. And by doing that, again, that disposes of their interest. And they have the right to do that. Now, having said that, can the landlord put in the lease, tenant, you do not have the right of disposition? In other words, a lot of times they'll have verbiage in there, you cannot sublet or assign this lease without the permission of the landlord or something of that nature. Can the landlord put that in the lease? Basically deny the tenant this right. Yes, they can. And assuming the tenant signed the lease, then tenant, you agreed to waive your right of disposition. But the point is, if there's no verbiage in the lease that takes away this right, then tenant, you do get the right of disposition, meaning to sublet or assign. And then the final one is obviously the right to quiet enjoyment. I'll ask the question, well, what does that mean, to have the right quiet enjoyment? And people say, well, you can't make, other tenants can't be making a lot of noise, and I got a right to be here in peace without a bunch of noise and whatnot. That's not what they're talking about there. Quiet enjoyment means you have a right to be here, excuse me, without any harassment. For example, can a landlord just show up on Saturday morning at 8 o'clock and say, surprise, I'm here to do an inspection? No. That would be considered harassment. Now look, you can call and coordinate or schedule a time to come out and look at the property, but you cannot harass the tenant. If the tenant feels like for any reason they're being harassed, for any reason, then that's a violation of their right to quiet enjoyment. And they could take legal action against the landlord in a situation like that. Okay, so y'all make sure you know the bundle of legal rights. There's 5 things there. They'll likely ask you about that on the state exam, so you certainly want to be aware of it. And not a whole lot to the non-freehold or leasehold estates. Just not a whole lot to it there. But one last success tip I do want to leave with you. And it's in Proverbs 16, chapter 16, verse 3, where it says, commit your works to the Lord and your plans will be established. I love that. That's a great tip. What you're doing right now, are you doing it for yourself or are you doing it for God? Big difference there. If what you're doing it for God, your works will be established. Praise God. Have a blessed day.